I'm Malcolm Heath. I'm the Legal Risk Manager at Lawcover, and that's it. My role is very much in the practice support services side of Lawcover, which is assisting law practices to try and help them reduce professional indemnity insurance claims.
Are you a lawyer?
I'm not.
You're not a lawyer. Do you have an opening statement you wish to make to the Commission?
Firstly, I'd just like to congratulate the Commission President on presenting this inquiry. I think it's invaluable and highly topical and timely, given the extensive change that is occurring in the legal profession, other professions and the broader community.
Thank you. Could you just describe your role in terms of dealing with lawyers?
Yes, certainly. My main function is to visit law firms who may have had a claim or have made a notification of a potential claim, and we contact law firms to invite them to undertake what we call a practice advisory service. It's a totally confidential process, and the aim of it is to visit the law firm, do assessments of the practice to try and identify where we think there could be risks in terms of claims-prone situations. We then review that. We put in a recommendation in terms of an action plan, and it's at the discretion of the principals of the law firm to undertake those actions or not. And it's very much a supportive role to try and help improve these services, to really come in as an independent body and do an assessment, and it's very much a supportive role. And we have the actuarial evidence now to support that what we do actually helps reduce claims. We have another service, it's called the Adverse Risk Category Service, and therefore law firms which may have multiple claims and claims that are large in quantum, large in amount, so there's some more significant problems. They're also invited to undertake a risk review. They don't have to, but if they do, it's a more comprehensive risk review, and we do quite a detailed action plan. We then do a follow-up of those action plans. The action plans are expected to be undertaken, and then we do a review of those action plans also, because we're trying to help assist those practices in reducing some of the significant problems that they have, and also provide better services to the consumers of legal services.
Can you just describe some of the more common risks that might affect lawyers and law firms that you've come across?
Yes, it's broad-based and many from what we've seen. I was a consultant to Lawcover in 1995 when we introduced the Risk Management Education Program. That's a series of workshops which I also am one of the presenters at. It was born about due to the increase in premiums and potential doubling of premiums, I believe, in the late 80s, early 1990s. Such was the change in the market where consumers of legal services, where they thought that there was going to be some type of financial loss, sought compensation and started suing lawyers, and quite significantly for the first time really historically. A review was done by Lawcover to look at what's going on, why are these claims occurring, and from that report was done identifying a number of areas which still run true today. Typically it comes down to communications with clients as being one of the major problems. Almost half of all claims are a result of a breakdown in the communication between solicitor and client. Systems and documentation problems are around about a third of the issues that occur. We even have a large number of, or percentage, around 7 to 8% per annum of claims where there's no negligence but cannot prove it, and that will come down simply to the inability to have the comment, the conversation by the solicitor documented, the classic file note, or ideally the letter as well. And so it's very difficult for the solicitor to therefore defend an allegation of negligence if there isn't that evidence. They're the key fundamental components, but through these firm visitations, which I've been doing since 2008, it's been obvious that there's a scenario of business risks that come into play. Many of the firms that do struggle with claims, there's a high correlation between poor business understanding, poor pricing understanding, poor cash flow management or understanding, the inability to measure the work in progress, the WIP, and the inability to identify the legal services offered and the profitability of those services. For example, a law practice may say, look, our conveyancing practice, we're really busy, we've had an increase in 20% in workload, we've taken on another staff member, things are going really well. And the question I may put to them is that practice area profitable? Of which there'll be a pause and a lowering of the eyes, because there isn't the understanding of it being actually profitable. On a further investigation, look at those legal services, whilst it may be busier, due to often discounting. Lo and behold, it's actually unprofitable, and it's actually being a detriment to the practice. The financial pressures are significant because that's when the practitioner may take on shortcuts and delegate more work to less qualified staff, cut corners like that, and become a little bit more desperate to try and bring in the revenue for the law practice. It's, from my observations, it's particularly difficult in the legal profession for the smaller firms, a lot of pricing pressures. And in the communication side of it, it's not just the communication between the solicitor and client that it's so important, it's the communication about what it is that the lawyer is doing. And so I'm trying to encourage practitioners to talk less about price and more about value, and communicate what it is that the lawyer does, the thinking, the application, the scenario planning, the wake-ups in the middle of the night thinking about what ifs, what should I do, the weekend, all the thinking that goes on, and what it is that the solicitor is actually doing in terms of helping the consumer of the legal services. I think there's an enormous gap between that expectation. So whilst the focus is often on the client expectations, it's often not communicated what the solicitor's communications and value is to the practitioner. Draw that back to, say, conveyancing back in the 1980s when there were scheduled fees. And so whatever the property price was, you drew a line across and that were the fees. There was no need to explain the value of the legal service, it was just done. And the conveyancing is just a transactional word. It has no real meaning to the consumer, yet too often we hear that the fee that's complained about most in a property purchase or sale can be the conveyancing. And that can be one of the smallest fees. So there's a disconnect there between the explanation of value and the impact, so-called impact of that fee. Yet when you think about what the law firm and the practitioner is doing is securing or assuring that asset is actually owned by the consumer of that legal service, that's possibly the greatest part of that transaction, I would think, rather than perhaps what the real estate agent's work is or the auctioneer's work is, not underestimating or undermining what they do. But there is a real price gap there. So it's that need to refocus and the importance of refocusing, particularly in this marketplace, about the value of the legal service. I will go back to the pricing as a problem and discounting. Many practitioners discount, and I'll say, why do you discount? We bring in more work. Okay, do you measure that? Have you checked that you actually bring in more work by discounting? Well, what do you mean? We've discounted because our firm down the road is charging that amount, or the conveyancing practice down the road is charging that amount. So it comes down to a pricing policy issue then too, because where's the sophistication in your pricing policy if you don't know what your cost of production is? How much does it cost to produce 1 hour of legal service? Yet you're pricing according to a competitor down the road. You don't know their overheads or cost of production. It's like throwing a dart at the dartboard, working out your pricing. And it's a big risk. And the discount may not be working. And what is it that you're discounting overall? What does the consumer expect to be a good discount? 5%, 10%, 20%? Who knows? Is that attractive? What is it in terms of the profit that you're discounting? Because whatever your cost of production is and the profit margin above that, you're discounting on the profit. So a 10% discount to the consumer may be a 30% discount in profit, for example. These are some of the messages that we try and get across to highlight that risk of pricing alone.
You've obviously visited a large number of firms over your career. How would you describe the changes that have been taking place within that range of firms that you've seen in terms of size of the firms, working smarter, technology? Are those issues affecting them, or are there other issues that are affecting them?
All of them and more. I read in the newspaper that a senior practitioner left a large law firm and joined another one. And you're probably thinking, what am I talking about? I read that in 1988 in the Financial Review front page. It was scandalous that a practitioner back then would dare think about, let alone actually leave a large law firm to join another. You know, the whole profession has changed substantially. We look at back then, in the early 90s, the Law Society defined a large law firm by 20 plus partners. We look back then to the phenomena in technology of the facsimile machine and the threat and risks that was presenting to law practices in terms of delivery of legal services. What happened when you sent the paper through the fax machine? Where did it go? Who was the recipient? Was it received? We'll send it in hard copy as well. And what happened? The receiver would put that facsimile in the file diligently, and within a few months, you couldn't read anything on it because the thermal paper, the print just came off it. So these were the technologies we were dealing with back then, which sounds ludicrous. And Richard Susskind talked about in the 1990s, he's a international consultant on legal technology, talks about when he thought that in the 1990s he had the audacity to say that email would be the main form of communication between solicitors and clients in the future. And he got an absolute hollering from some authorities in the UK for saying such outlandish things, and it was recommended he shouldn't speak publicly again. And we know today with email where it's going. The technological change has been phenomenal. I look at the medical profession as an example with expectations, because we look at client expectations and who's driving the expectations. And the question I'll raise is, well, let's look at the medical profession. Back in the, say, the 80s, you could access your GP or a GP from that medical practice 24 hours a day, 7 days a week. Someone would be on call. Today, it's a little more difficult. When I'm presenting workshops, I'll ask practitioners who gives out to their clients their telephone, direct line, their email address, mobile, who's accessible after hours, and what does after hours mean? Does it actually mean 24 hours a day? Are you accessible on weekends and holidays? And there's a decreasing percentage of practitioners from telephone to then being available on holidays. What about your GP, your medical specialist, who has their direct line, who has their email, who can contact them after hours on weekends or holidays? So it's just to point out the expectations, who's driving the expectations. When a client or a patient goes to a medical practice and goes to reception, the receptionist will then direct that patient to the room called the waiting room, where one waits. However, in the law practice, it's the reception and asking practitioners how long would they leave a client waiting in reception. Worst case, 3 minutes, maybe 5. And then I ask, what's your experience with going to a medical practice in terms of waiting? And if there is a delay, are you receiving a text to say we're running 30 minutes, 45 minutes, an hour late, please come back later? So these are the expectations that I think the profession actually is also helping stimulate, and I can understand why, because another significant change has been the growth in solicitors in the profession. And an example, in year 2000, there was about 11,800 practitioners practicing in New South Wales in private practice. Today it's close to 20,000. It's been phenomenal growth over that period of time, where the New South Wales economy has been relatively benign, about a 2.8% state domestic product. In the regional areas, 2.3. In the regional areas, it's about 1.8%. That's on a per annum basis. So whilst WA and Queensland had the luxury of the resources booms and had fantastic state domestic product, which helped our national side, our New South Wales economy has been relatively flat, which puts more pressure when you've got more solicitors practicing in a relatively same financial pool. So that competition is significant. Technology is major. I see some sole practitioners who, when I talk to them about their backup systems, they'll hold up their USB stick. That's their backup. Of course, you can see the whole spectrum towards the larger law firms who've got that pretty well in play. There's many who have a lack of understanding or awareness of what's happening in the greater community. And it may be the things that are directly affecting the legal profession. When I ask practitioners about the Commission of Inquiry into Legal Services, the Productivity Commission's report that was submitted to government in January 2015 on the access to legal services, few are even aware of it, let alone of its contents and the potential ramifications if a government decides to act on any, none, some of those recommendations. Yet there's direct recommendations that can impact on the future of some law practices. So I see that there's actually a lack of awareness of the marketplace, the inability to really SWOT, to do the strengths, weaknesses, opportunities and threats, and what's occurring.
Thank you. Any questions?
No.
Thank you very much for your time. Very much appreciated.
Thank you.